All right, so ending a representation. Obviously, at some point, the representation comes to an end, either voluntarily or involuntarily, and there are a lot of issues that are involved in that, so I want to give you my thoughts on that. There's kind of two different types of ending the relationship. Either you want to end the relationship, you want to withdraw, or maybe you are required to end the relationship. So first, and I harp on this in other videos, but it's really important, the termination, or rather the scope of the relationship, should be set forth in detail in the retainer agreement, so that there's no question that after these events occur, this particular representation has terminated. Otherwise, you can get pulled into other matters that you weren't planning on. Clients saying, wait a minute, I paid you this money, you have to do this for me. And you want to be able to have the retainer agreement and say, no, what you paid for was this, and this is concluded, we're done. That's the first thing I would warn you about. Now, what are the situations where you must withdraw? Well, if, and this is what the professional rules say, if the representation will result in the violation of the rules of professional conduct. So if there's something that the client wants you to do and you can't change their mind that would violate your obligations under the professional rules, you must terminate the relationship. You do have to make some effort to talk the client out of it and explain why you can't do that. And if they're not moved, you say, I have no choice. I cannot violate these rules. I'm going to have to terminate our relationship. Also, it says if there's any physical or mental conditions which would impair your ability to properly represent the client, it's pretty obvious. If there's something going on, you'd have to go to your client and say, I'm no longer, we do have a retainer agreement, you did pay me, and there might be a refund, but I'm no longer able to continue here. And the other reason that you must withdraw is you get fired. And let me tell you something, in your career, you're going to get fired. A client has an absolute right to hire any lawyer he or she wants and can fire you for any reason or for no reason. So you got a great case, you're doing yeoman's work, the results are great, and the client comes to you and says, I really like you, you're doing a great job, but my nephew just graduated from law school and I want to give him the case. You're done. There's nothing you can do about it. And that's going to happen. Or maybe the client thinks you're not doing such a great job and goes to another lawyer and there's a consent to change attorney. That's going to happen too. Now, there are other circumstances where you may withdraw. And one of the things that the professional rules talk about is you can withdraw so that there's no material adverse effect on the client's interest. You want to get out, okay? Maybe you have a good reason to get out, but you can't do anything that would materially cause a material adverse effect on that client's rights. You have to really give that some thought. You may decide that even though you want to get out, based on maybe the progress of the case, how far you're into the case, that you really can't pull yourself out without having some effect on the client's rights. You may have to stay in. That's why in other videos I talked about giving some thought to a case before you get that retainer agreement signed. Because once you're in, and it may not be so easy to get out, and you may want to get out at some point, and you may not have the ability to do that. Obviously, if there's any criminal or fraudulent conduct that the client's engaged in, you can't be any part of that. You may try to tell the client that this has to stop or I have to get out. If they're reticent about that, get out. If you have a fundamental disagreement with the client, and sometimes the clients want you to do something, it's not unethical, it's not illegal, it's not improper, but you really have a problem with it, you think it's a really bad idea. You got a couple of options here. You can draft a letter that you're making the client sign that says, I think this is a really bad idea, this is against my advice, this is what I think is going to happen if you do it, but if you want to continue, you need to sign this. This is not something that I advise you to do. You could do that. Sometimes what the client wants you to do is so adverse to what you think is in the client's best interest that you just say, I can't be any part of this. You have the right to any lawyer you want. You're going to have to go to somebody else if that's what you want to do. You may find somebody that won't have a problem with it. I do, so we're done. Now, and this is what the rules say, if the client substantially fails to fulfill the obligations and you warn them about it, there's something they're required to do in the retainer agreement that they continuously refuse to do, you can go to the client and warn them and say, you're making my ability to represent you very difficult, and this is a material default in the retainer agreement, and if you don't change and start fulfilling your obligations, I have to end our relationship. If you've given them warnings, make sure it's in writing, you may be able to get out. Well, what about not being paid? Is that a material breach of a retainer agreement? I would think so. And the commentary in the rules talks about an unreasonable financial burden. In other words, the client for some reason has stopped paying you, and you're putting time in, but you're not getting paid. If you do it correctly, and if you warn the client that I cannot continue unpaid here, I'll have to withdraw as your counsel if you're not fulfilling your obligations to pay me, that might be considered an unreasonable financial burden, and you might be okay. And then finally it says for any other good cause, like any other rule, regulation, statute, what the heck does that mean? I guess it means what your local disciplinary body says it means. When you're in litigation, you're in a whole different matter. So you've appeared in a court on behalf of a party, the plaintiff, the defendant, whomever. It may not be easy to get out, because when you're in litigation and you've appeared as the party's attorney, you need the permission of the court to withdraw. You just can't withdraw. You're a officer of the court. You've appeared in that court. You can't just not show up. You have to make a motion, and you have to tell the court why you want to be removed, and the court's going to go through all those factors that we talked about to decide whether it's going to let you out, and it may not, and you may be stuck in a case, litigating it to the end and not getting paid or whatever the other problem is. So these are some of the thoughts that I have about ending or terminating a representation.